Hello, and thank you for joining us today. I'd like to welcome everyone to today's webinar, Paycheck Protection Program 2.0, What Borrowers Need to Know. This presentation will last 90 minutes. This webinar is available for CLE credit in California, Colorado, Georgia, New Jersey, New York, Pennsylvania, Texas, and Washington, and is pending approval in Florida, Illinois, Ohio, and Virginia. For all other states, credit will be applied for as requested. Please be advised that there will be 2 points during the program where we will pause for CLE codes. During this time, a code will appear in the slide deck you see on your screen. Please make sure to write down this code if you are seeking CLE credit, as you will be asked for it at the conclusion of the presentation. A CLE program evaluation will be available immediately following the conclusion of the webinar at 12:30 Eastern, where we will ask for your bar number and the 2 CLE codes. If you have questions, you can submit via the Q&A box in the Zoom platform. We will do our best to address them toward the end of the program. Now, I'd like to take a moment to introduce today's moderator, Patrick Campbell. Pat is a member of BakerHostetler's White Collar Investigations and Security Enforcement and Litigation team. He focuses his practice on white-collar criminal and civil regulatory matters and internal investigations, specifically in the areas of securities, construction, corruption, asset forfeiture, and money laundering. He represents clients in highly sensitive federal and state investigations conducted by the DOJ, SEC, CFTC, FTC, and New York Department of Financial Services. Pat also regularly counsels clients on best practices for corporate governance and ethics and compliance matters. Pat is chair of the New York City Bar Association's Compliance Committee. Pat, we'll turn it over to you to begin.
Thank you, Kristen, for that introduction. And I hope that everyone is staying safe and healthy. And thank you all for spending some time out of your late morning to attend this webcast. As Kristen mentioned, my name is Patrick Campbell. I'm a partner in BakerHostetler's White Collar Group. Today, I will be your moderator for the program. We're going to discuss what you see on the opening slide as Paycheck Protection Program, what we've called 2.0, what borrowers need to know. PPP 2.0 is the reopened and expanded Paycheck Protection Program under the Economic Aid Act. Today, we're going to give you an update on the program, what's changed, what remains the same, who can take loans, who can't take loans. We're also going to give you an update on the enforcement risks and trends and best practices steps borrowers can take now to avoid being on the wrong end of a government investigation or enforcement action later on. But before we get started, I just wanted to remind everybody a couple of things. First, you'll note what's written on the what's written on the intro slide at the bottom. What we're going to be discussing today and the materials that you'll receive later on after the webinar are for informational purposes only, do not constitute legal advice or accounting advice. And the reason why I reiterate that here is because the rules surrounding the PPP 2.0, really all the CARES Act loan programs are constantly changing and evolving, and they can be complex. So you should always consider getting legal advice, getting accounting advice when considering taking loans out of the COVID relief programs, and also when you're at the point of trying to seek forgiveness for those programs. I also just wanted to remind everybody, if you have any questions, feel free to put them into the Q&A box, and then they'll either come up during our presentation, or we'll try to address them at the end, time permitting. So now let me just introduce today's panel of experts. And if you could go to the next slide, start with Alexandra Smith, who is the chief of the Business and Securities Fraud Section, the U.S. Attorney's Office for the Eastern District of New York. While at the EDNY, Alex has investigated and prosecuted a wide variety of criminal matters, including for market manipulation, insider trading, healthcare fraud, and corruption. Some of Alex's significant white-collar cases include being the co-lead prosecutor on the Martin Shkreli prosecution, and she also led the EDNY team that investigated and prosecuted the US v. Odebrecht and US v. Brascom, collectively one of the largest foreign bribery cases in history. Next is Camille Bent, who is a bankruptcy and restructuring partner in BakerHostetler's New York office. Camille concentrates her focus in the areas of corporate bankruptcy, financial restructuring, and commercial litigation. She represents debtors, creditors, trustees, and other interested parties in all different industries. Camille is also a member of the New York City Bar Association's Bankruptcy and Restructuring Committee. And then we will move to George Stamboulides, who is the managing partner of BakerHostetler's New York office and co-leader of the firm's Chambers USA ranked white collar group. George is a former EDNY prosecutor, where he was, among other things, the deputy acting chief for the office's organized crime section and chief of the office's Long Island division. George has tried dozens of complex federal jury trials as a prosecutor and as a defense attorney, and regularly counsels clients on FCPA issues and other criminal and civil white-collar matters. George has also been appointed as a federal monitor several times. And then we'll move to Peter Group, who is director at Protiviti Forensics, a global risk and consulting firm. Peter provides consulting services to companies and individuals around the world, conducts complex white-collar investigations of financial crime, bribery, and misconduct, and he also assists clients with FCPA program compliance and investigations. Peter has held various executive management roles with the FBI. He spent 24 years as a special agent in charge of the FBI's New York white-collar branch, where, among other things, he successfully managed the largest Ponzi scheme in history and the largest insider trading investigation in history. And then you'll see the slide on me, which Kristen already gave me her very generous introduction. Now, let me just run down today's agenda. We're going to start with discussing the reopened and expanded PPP. We'll discuss the key changes and also key things that have remained the same, including with regard to loan forgiveness. And then we'll spend a few minutes on the Economic Injury Disaster Loan Program and how the Economic Aid Act expanded the advanced grant program under that loan facility. We'll then discuss enforcement risk and trends. Alex will give a general update on PPP criminal enforcement, and George will discuss civil actions. They will also discuss the outlooks. And we'll finish with risk mitigation steps borrowers and potential borrowers can take now to mitigate these enforcement risks. And you'll note the quote on the bottom of the slide by William S. Sweeney, who's Assistant Director in charge of the FBI's New York office. The FBI will continue to aggressively pursue those who are using the money from this taxpayer-funded economic relief program to pad their own pockets. And he was talking about Paycheck Protection Program and EIDL. So, you know, this really sets the stage, I think, for today's webcast. Law enforcement has aggressively pursued alleged COVID relief fraud, and all indications are that they'll continue to aggressively pursue COVID loan relief fraud. So, you know, it's really important that borrowers who take loans under the programs stay abreast of the rules, consult, you know, with folks who know the rules and know the calculations, and also just be, you know, stay extra diligent when participating in these programs because it's a priority for law enforcement. And as we'll discuss later on, there's a heavy audit activity with respect to these loans and with respect to the forgiveness portions of these loans. So, you know, that's really the reason why we're speaking to you today. So if you go to the next slide, just a quick recap of where we are before I turn it over to Camille to start discussing PPP 2.0. As you see on the slide, you know, the EIDL advanced program was shut down on July 11th, distributed more than 20 billion in advanced funds. It was heavily utilized, both the advanced program, which gives grants of up to $10,000 per employee that you don't have to pay back, and along with the regular EIDL relief program, which was in existence before the COVID-19 pandemic. Then you have on August 10th, the first iteration of the Paycheck Protection Program closed after distributing over 525 billion in loans. Interestingly, there was over 100 billion left out of that program. At the time it was closed, over 100 billion that was authorized under the CARES Act, which established the program. We've all been privy and about the public demand for new stimulus package, the months of negotiations that involved, and ultimately led to the next stimulus legislation that was passed on December 27, 2020. That was enacted into law, I should say. And part of that stimulus legislation was the Economic Aid Act. And that's what we're going to focus on today, which is the Economic Aid Act and how it provided an additional $284.5 billion for reopening and expanding the Paycheck Protection Program, and how it provided $20 billion in funds for EIDL advance grants. On January 19th, the PPP 2.0 portal reopened for all borrowers, and as we'll get into in a couple minutes, you'll see that it's open for first-time borrowers and also for certain qualified borrowers who took loans and wish to take another one, and they're called second draw borrowers. The portal actually opened on January 11th for small loans and opened to all borrowers on January 19th. And it's been heavily utilized so far. So as of February 15, 2021, according to the SBA, over 125.7 billion has already been approved under the new Paycheck Protection Program. So, Camille, why don't you get us started by talking a little bit about the eligibility and the revived PPP.
Sure. Thank you, Pat. So you all heard from Pat that the portal reopened last month on the 19th and will close next month. So from here, we want to take you through some of the key highlights and the differences with what we're calling PPP 2.0. So we have here some of the highlights. They were guaranteed by the SBA. They continue to not require collateral or any personal guarantees. Great rates. You have a 1% interest rate, 5-year maturity, and hopefully you get the loan forgiven at that time. And then the lenders will continue to rely on the borrower's certifications regarding loan eligibility and compliance with the PPP rules. Next slide. So the main thing to understand here is that the Act really divides the loans now into two groups of people. The first group is those borrowing for the first time, or the first draw PPP loans. And again, a lot of the eligibility requirements will look the same. A lot of the limitations will look the same. A few that we have highlighted here. You must have 500 or fewer employees to meet the industry size standard. And, you recalled before that there were some companies that were in the news for being too big, right? And trying to take out these loans and ending up giving it back. One thing that we wanted to note is that the accommodation and food services category, they have a special eligibility requirement for them, and that is that they have if they have more than one physical location and they employ less than 500 employees per location, then they are eligible. So that does open it up to a few other companies. And you'll see that if you look at the breakdown, which I don't have here, but I'll share with you, that that sector, accommodation, food services, they're consuming about 19% of the approved loans so far. That's about as of the end of last month. So only a couple weeks into the time period for the portal being open. And then another thing to note here is the alternative size standards. You can apply for the PPP loans you can apply for a first draw PPP loan if the borrower plus any affiliates have a maximum net worth of not more than $15 million and an average net income after federal taxes for the first 2 fiscal years before the date of application of not more than 5 million. Yes, that's a mouthful. So You really want to pay attention to the eligibility requirements, pay close, very, very close attention to the affiliate rules, because again, this is where some companies have run into trouble. The other thing I'll mention here is that you cannot have an owner be a part of the bar. You can't have an owner of the borrower that's at least 20%. That's any of these things listed in this bullet point. So incarcerated, on probation or parole, subject to current indictment or an information, which gets a little tricky, a little interesting. You want to take a close look at that. And then, or has a felony conviction in the last 5 years. So keep that in mind as well. What's the most you can borrow? You can borrow up to 10 million for most groups. And how you calculate that is you look at 2 times the borrower's average monthly payroll costs, and they cap that at $100,000 per employee. And actually, if that part is lower than 10 million, then that's the max you can borrow. If that part reaches 10 million, then you can only borrow up to 10 million. And then you have to certify again that the current economic uncertainty makes the loan request necessary to support the ongoing operations of the applicant. That's front and center in the application when you submit it to the lender. Have to make that certification. And I'll pause there to say that, and we'll probably refer to them throughout the program, that we have a number of documents included in the packet of information. It includes the application and a few other key documents that that it's very worthwhile for you to take a look at. Other requirements, the borrower must have been in operation at the very beginning. February 15th of last year. It's kind of hard to believe that the pandemic, it's been a year already. But as of that time, you have to have been in operation, and you had to have had employees or independent contractors on the payroll as of that time. These last 2 bullets are pretty quick. You have to have publicly traded companies and businesses in which, the president, the vice president, most people at the top of the company, if they own more than 20% of any class of equity, then they're excluded from eligibility for the first draw PPP loans. So keep that in mind as well. And then the other thing is, if you were a PPP borrower the first time around and you used up, if you returned the funds or you didn't accept the full amount of the initial loan, you can apply as a first-time borrower, for the first draw PPP loan. So that's an interesting point to note. Next slide. Thank you. And so the second group, right? The second draw PPP loans. There are some additional restrictions. You're talking about people who drew down on the first loan, may have some money left, or they used up all the money, and we'll talk about that. And they want to draw down the second time around. It's a little bit tighter. You can only have 300 or fewer employees as opposed to 500 before. You have to prove that you had a 25% reduction in gross receipts in one 2020 quarter, and then you have to compare that with the same quarter in 2019 when things were, quote, normal. It has to be 25% less in revenue, in gross revenue. And then, and this is what I mentioned very briefly, the borrower has to have used up all the funds from the first PPP loan by the time you get to the expected date of disbursement for the second draw. So keep that in mind as well. And then with the maximum amount, it's a bit lower. The absolute cap is a bit lower. Whereas before it was 10 million, here it's 2 million. And you can borrow, it's calculated the same way. You look at 2 times your average monthly payroll costs. You still have the $100,000 cap per employee. And if that's lower, you go with that number. But the absolute most that you can borrow as for a second draw loan is $2 million. And then again, special considerations for the accommodations and food service sector, which was very hard hit. They get to borrow up to three and a half times the borrower's average monthly payroll costs. Next slide. Oh, I thought, okay. Okay, so here the question is, you're eligible for the loan. What can you use it on? What can you use the funds on? What can't you use the funds on? A lot of the use restrictions are just like before. You can use it for payroll costs, again, capped at $100,000 on an annualized basis for each employee. You can use it for healthcare related costs and insurance premiums. You can use it for typical business costs like rent, mortgage, interest, utilities, interest on other debt, refinancing of other SBA loans. And then they have a number of other uses in the Small Business Act that they list. Like before, 60% of the loan proceeds must be used for payroll costs. And with PPP 2.0, there are a few additional costs. So you can use them for worker protection costs, uninsured property damages, like looting or vandalism that occurred last year. Or you can use them for certain supplier costs and expenses for operations. Some examples of that, goods that are essential to the operations at the time that the expenditure is made. They don't really define that, but they give a little more detail there. And they'd have to be made pursuant to a contract order or purchase order. And they'd have to be in effect before the date of the PPP loans disbursement. And with respect to perishable goods, they'd have to be in effect during the borrower's loan forgiveness covered period. These rules can get pretty tricky, as you can see, even with me just explaining them. You definitely want to consult with a lawyer to make sure that one, you truly are eligible, two, that you're using the funds for authorized uses, and that you don't have any trouble on the back end when the time comes for forgiveness, which Peter's about to talk about. The last thing that I'll mention is that, well, actually, before I mention that last bullet code, I wanted to point out one thing that the PPP loans, they specifically say they cannot be used for lobbying activities. They can't be used for state or local campaigns. They can't be used to, quote, influence the enactment of legislation, appropriations, regulation, or administrative action. They specifically indicated that you can't use it for those items, for those activities. And so with that, the last thing that I'll mention is that they codified the ability of the lender to rely on certification and the documentation submitted by the borrower for the loan. And that's interesting because it's clearly a signal to lenders to encourage them to continue using this program, putting the onus squarely on the borrower, making sure that they understand that they will be on the hook here if they certify something that in fact is not correct or accurate. Pat?
Thanks, Camille, for that description. Yeah, that is interesting. The guidance had been out there about the sort of no fault or no harm lenders provision. It was codified in the Economic Aid Act. Lenders have other things to consider. This webinar is focused on borrowers. In your materials later on, you'll see a flash report from Peter's firm, Protiviti, that talks a little bit more about the PPP from the lender's perspective. So you can read about that later. I also, before I turn it over to Peter about forgiveness, I just wanted to sort of hit on a few things, Camille, that you mentioned. It's interesting because the PPP 2.0 both expanded and contracted. And I think a focus was one of the focuses anyway for the legislation was to target companies that really needed the funds. So I think that's where you see the restriction on funds going to publicly traded companies. That's a new one that was added on the Economic Aid Act, and I'm sure it was for one of those reasons where they wanted to be targeted so that the companies that needed the funds most will get the funds. And you also see that in some of the other restrictions, both on use as well. And then there were certain expansions, more expanded calculations, especially for the second draw loans for the food and accommodations sector, which has been one of the hardest hit in the pandemic, and also new costs, as you see on the slide now, that are eligible under the program. So it's just an interesting dynamic and balance, I think, that Congress tried to strike here with respect to both contracting and expanding the program. So now let's turn it over to Peter, who will talk to us about loan forgiveness.
Okay, thanks, Pat. So somewhat simply or generally, the difference between, let's call it PPP 1.0, the initial version, and 2.0, which we're dedicating most of the discussion here this afternoon on. In the first version, borrowers were required to submit a very detailed application when seeking loan forgiveness, demonstrating the use of funds required for all loans, regardless of size. And what's interesting, having been around or exposed to a lot of the disbursements of stimulus monies through the years, I think back to 2009 or so with the SIGTARP and comparing certainly from a forensic or fraud perspective, as I looked through this, it looks like 2.0, they've made a concerted effort to streamline, to certify, to simplify that process for receiving a loan forgiveness. And I think they've accomplished that, I think, in whole. Time will tell as we go through this and the covered period ends. So, very simply, what they've done is they've streamlined the application process, presenting more limited borrower data, and one particular, for loans less than $150,000, it's simply an attestation. You're not required to provide additional documentation. So they've offered certainly that as a big help to borrowers, provided other streamlined approaches to the application and the Schedule A, the calculation that one has to go through. The 3508S is that very limited version, resulting in an attestation that the monies were used for its intended purpose. One of the very, very key components here is whether it's $150,000 or less, or anything above and beyond that, with a full application and submission of documentation. The expectation is that you need to retain these documents and be prepared to discuss those upon request. 3508, again, is the revised loan forgiveness calculation form. 3508EZ, if a loan is more than $150,000 and it meets one of the parameters outlined below. For example, borrower did not reduce annual salary or hourly wages of any employee by more than 25% compared to most recent full quarter before covered period, and the borrower did not reduce number of employees or average paid hours of employees between January 1, 2020 and end of the covered period. Again, seeking to simplify the process, both from a borrower standpoint and a lender standpoint, in terms of trying to make this an efficient and effective process. Lastly, the Economic Aid Act requires the SBA to develop a plan that details policies and procedures for conducting forgiveness reviews and audits of covered loans and metrics to determine which loans will be audited. In the spirit of stimulus monies, and everyone would certainly appreciate that, the intent with a lot of government programs, whether it's Medicare, Medicaid, and the like, is to get the money out to the people that need it as quickly as possible. And that was certainly done in the first version of the Paycheck Protection Program. Upon reflection, they're able to think about streamlining the process, but also, okay, what loans do we look at? What metrics? Everything now is about big data and the ability to kind of go through the data effectively to identify those that may need to be audited. So that was another prong to the distinction between 1 and 2. Okay.
Thanks, Pete. If you could flip to the next, and we will now turn it over to Alex Smith to discuss the EIDL program.
Hi, so I always have to start with my standard government disclaimer, which is that any statements I make during the program are mine and don't reflect either the Department of Justice or the Eastern District of New York. So for the EIDL program, just to give a little bit of background, it's different than the PPP program in that it actually existed prior to the COVID-19 crisis. EIDL stands for Economic Injury Disaster Loan Program. And it's a program that the SBA has had in place for a long time that provides longer term loans at a favorable borrowing rate for small businesses that have been affected by a variety of different economic, natural disasters. And so when the COVID-19 crisis hit in the CARES Act, the EIDL program sort of continued as it did, but there was $20 billion put in the CARES Act. I believe 10 billion originally in the CARES Act, and then another 10 billion in the updated legislation in April of 2020 for what they called the EIDL Advance Program. And basically it created a pot of money for grants of $10,000 to eligible businesses. And the grants did not actually need to be repaid. And so the idea was it was a good way to get sort of money out the door into businesses that were otherwise applying for EIDL loans to give them a quick cash infusion until the loans actually came through. That $20 billion was used up, I believe, as Patrick said on the original slide, by July of 2020. And a lot of businesses that applied for grants did not actually get them. And so in the Economic Aid Act, in December 2020, there was an additional $20 billion infusion for a new advanced grant program. A couple of things to just note, the OIG for the SBA in July of 2020 noted that there was sort of widespread fraud with the original grant program. And the SBA has sort of been looking into issues with those initial grants and doing a review. And so I think some of those issues sort of informed how the targeted advanced grant program will work. But that's sort of the background for this targeted advanced grant program. In addition to creating the targeted advanced grant program that we're going to talk about on the next slide, the December 2020 legislation removed the requirement that either the original advanced grants or these new advanced grants needed to be deducted from PPP loan forgiveness. So originally, if you got a $10,000 grant, you needed to deduct it from the loan forgiveness that you might have on a PPP loan that you would have applied for. Now you no longer need to make that deduction. And the December 2020 legislation also extended the application process for EIDL grants through December 31st, 2021. So basically acknowledging that we're still in the middle of this crisis and that both you can apply for EIDL loans related to COVID-19 and grants through the end of 2021, though obviously given how quickly the original $20 billion ran out, it wouldn't be surprising if this $20 billion also ran out far before December 31st. Obviously, though, there's still funding for loans. To date, almost $200 billion in loans have been granted under EIDL. And the question is sort of how long this new pot of money will last for advanced grants. Just before we move on to the next slide, it's interesting to sort of note some provisions that were discussed for the EIDL program in December 2020, but not actually enacted. So there were various versions of the legislation floating around. Originally, the EIDL loans were supposed to be up to $2 billion, $2 million for individual businesses. The SBA, in an attempt to sort of, I think, distribute the funds more widely, has put an unofficial cap on those loans of $150,000. So they're much smaller loans than the PPP program permits. And there was some discussion of removing that unofficial cap and allowing businesses to seek loans above $150,000. That did not happen. And in fact, if you look at the statistics for EIDL loans, 99% of them are at $150,000 or lower. So it's an unofficial cap. It's not, the SBA doesn't say that they're only providing $150,000 loans, but that's sort of the size that they have let money out the door at, and the legislation didn't sort of prevent them or force them to give higher amounts of loans. And the second provision that was kicked around and not actually enacted was further reducing limitations for borrowers with a criminal history. As you saw with the PPP loans, there are limitations on actually applying for loans or grants under the EIDL program if you have a criminal history, which would include current pending charges. And there was a lot of discussion about potentially removing that requirement, which did not in fact happen. So all of those sort of criminal history requirements remain in place for the new targeted EIDL program, as well as EIDL loans going forward. So if we can go to the next slide. So this is the targeted advance grants, which is sort of the 2.0 of advanced grants under the EIDL program. As I said, the original advance grants sort of ran out by July of 2020, and the new legislation provides for similar advance grants of up to $10,000. Again, these are grants, they do not need to be repaid, and now under the new legislation, they do not need to be deducted from PPP loan forgiveness. That said, this pot of money is, there are many more restrictions on which small businesses are eligible, and there's also going to be a tiered system for how the money is paid out. That may mean, depending on sort of how the money, how quickly the money goes, that new applicants may not actually be able to apply. So just to look quickly at the eligibility requirements, you have to have obviously applied for an EIDL loan, and you have to be located in a federally designated low-income community, which is just defined under sort of the tax code. There's a designation for what that community means under the IRS, and that's the definition that the SBA is going to use for low-income community. You have to be able to show that you suffered a 30% reduction in revenue during an 8-week period after March 2nd, 2020. You have to have fewer than 300 employees, and you cannot be an agricultural enterprise. I should also note that your business has to have been in business on or before January 31st, 2020. So you can't be sort of a new business that's come, that's been established after the crisis started to apply. You have to be in business before then. And so if you are eligible, you could apply for a targeted EIDL advance loan. The sort of complication is that first priority is going to be given to eligible businesses who previously either received an EIDL advance of less than $10,000 or previously applied for an EIDL advance and did not receive it because the funding ran out. And in fact, right now, the SBA is not actually taking applications for targeted EIDL advance grants. They are only looking at borrowers who fall into those sort of first two categories. Either you got less than 10,000 originally, or you didn't get anything. And they are affirmatively, and by they I mean the SBA, reaching out to businesses to let them know whether they fit into one of these two categories and are not allowing new businesses to apply. So it'll be interesting to see whether or not they run through that $20 billion with businesses that either received less than the 10,000 originally or applied and got nothing originally, or if there will be money left in that $20 billion pot for new targeted advance grants going forward.
Thanks, Alex. Kristen, I think you can move to the next slide. There's your CLE code.
Please record the code RISK1 for the post-program CLE evaluation. Please make sure to write down this code if you are requesting CLE credit, as you will be asked for it at the conclusion of this program. That's risk and the number 1.
Thanks, Kristen, for that. So now we're going to move on to the second component of our presentation today, which is enforcement developments and enforcement trends. And before I turn it over to George, I just wanted to give just a quick recap on the oversight mechanisms for what were established under the CARES Act and still apply today. And it was like a 3-pronged approach. So you see before you, George is going to talk about the SIG-PR. There's also the Pandemic Response Accountability Commission, which is made up of 22 or 23 IG offices. So that commission is involved in CARES Act loan oversight and enforcement. And you'll see when we turn it back to Alex in a little bit on the criminal actions that the IGs are heavily involved, different agencies in investigating alleged CARES Act loan fraud. And then you have the Congressional Oversight Commission, which has been mainly focused on the Main Street Lending Program, which was not renewed, which ended December 31st, and loans that go to businesses that are essential for national security, certain transportation companies and logistic companies. We're not discussing those today, but the Congressional Oversight Commission has focused on those and not so much on the PPP. You also have the GAO issuing bi-monthly reports. They've talked a lot about the SBA's need to audit and to provide more oversight over the PPP loans and the IDL loans. And you also have a House Select Subcommittee on the coronavirus crisis, which in the past has done the same thing with respect to identifying issues with the PPP and the IDL and encouraging the SBA to have a strict oversight over it. Those oversight mechanisms, GAO, and others have a broad scope. So it's not just loans, it's pandemic recovery funds overall. And they each have their sort of jurisdictions and slices of those. So that's the sort of quick overall. And George, what's going on with the SIG-PR?
Thanks, Brian. Pat. So as we noted in prior webinars, the SIG-PR is similar or has been compared to the SIG-TARP, the Special Inspector General established during the 2008 financial crisis. And the SIG-PR is authorized to conduct audits and investigations of funds distributed under the CARES Act. So his history would suggest a lot of activity. His background, he first of all, he was confirmed as is noted in June of 2020. He served as an IG of the GSA, the General Services Administration, in the past during the administrations of George W. Bush and Barack Obama, from the summer of 2005 to May of 2014. Before that, he was an advisor to the U.S. Deputy Attorney General, and he was an AUSA in the Eastern District of Virginia during the Bush administration. While he hasn't been identified in any publicly filed actions yet, he did note in his February quarterly report to Congress that his office spent a lot of time in the early stages setting up the office, and obviously challenging in the midst of a pandemic, but is now operational and moving forward and going to be aggressive. He's entered into MOUs with memorandums of understanding with U.S. attorneys' offices and regulators, and he has noted, I guess, a potential twist to the expected level of his enforcement activity, that he questions whether he has jurisdiction over PPP. And it's widely assumed that he would play a major role in any PPP fraud, but he's raised that, thrown it out to Congress to see if they will give clarification. As of yet, they haven't provided any clarity in the Economic Aid Act, and the SIG-PR has not spoken further or addressed further on that. So left with a little bit of an ambiguity as to what his role will be and whether he has authority as to over PPP. That said, he has highlighted multiple dipping as an area that he'll go after. And obviously, if multiple dipping, taking funds or seeking funds from different federal programs or loan programs to pay for the same thing and or get money twice for the same reason, he characterizes as double dipping. And if he has jurisdiction in another area, and while it's ambiguous as to where there's jurisdiction in PPP, if part of the double dip came in an area that he has jurisdiction, he will be pursuing that. There are instances where he issued guidance, including back on June 18th. Guidance was issued by the OMB, the Office of Management and Budget, addressing administrative relief designed to assist recipients of certain federal grants. Part of the relief discussed in the OMB was to allow certain grantees to continue to charge salaries and benefits to active federal awards, even while those grantees were forced to suspend project activity. But the guidance specifically warned that, quote, payroll costs paid with PPP loans or any other federal CARES Act programs must not also be charged to current federal awards, as it would result in the federal government paying for the same expenditures twice, close quote. So the SIG-PR agreed with that principle and highlighted it. And he characterized that essentially double dipping would represent waste at best or fraud at worst. So, so even though he doesn't, as I noted, even though he doesn't have may not have jurisdiction or questions whether he has jurisdiction on PPP, he will investigate potential multiple double dipping involving other programs that there's no question that he has jurisdiction over. Let's see. So second, the other thing that remains to be seen, one would assume things will continue as they are, but President Biden could replace Miller and put in place a new SIG-PR. I wouldn't expect that, but who knows? And the new SIG-PR, if one were installed, might not feel as compelled to be bound by Brian Miller's interpretation of his jurisdiction as it relates to PPP. So that's something else that could be seen. And the SIG-PR's level of activity as it relates to PPP is still something we'll be watching. Next slide, please.
Thanks, George. So despite the SIG-PR as of yet not being involved in PPP enforcement, there has been plenty of it. And I think we'll start with Alex on the criminal side.
So on the criminal side, we have the statistic at the top of the DOJ fraud section, which obviously is sort of the main justice as opposed to the U.S. attorney's offices. But on a lot of these cases, they partner with U.S. attorney's offices. So I think it's a good benchmark. But that as of January 2021, in conjunction with other offices, DOJ fraud has prosecuted more than 100 defendants in more than 70 criminal cases for PPP loan fraud and seized more than $60 million in assets related to such frauds, which is obviously, a very small percentage of the overall PPP program, but represents, I think, sort of the tip of the iceberg of potential fraud prosecutions. I think, as we said in prior iterations of this presentation, the initial prosecutions on the criminal side were sort of the really obvious cases where borrowers were applying for businesses that didn't exist or vastly inflating the number of employees. And I think a lot of these sort of initial prosecutions in 2020 into early 2021 are sort of along those lines. But I think as time progresses, you'll expect to see, additional more complex prosecutions of borrowers. And we're also going to obviously move into the PPP loan forgiveness phase. And so I think there's a potential for prosecutions on fraud connected to those aspects of the program as well. But what you've seen so far, sort of, as I've said, is sort of basic prosecutions of borrowers who provided false information in their loan applications and received proceeds as a result. I've included a case from ED&Y, my district, from October of 2020, where the defendant was charged with wire fraud for submitting false applications for an EIDL loan and an EIDL advance. So this is an example of where the $10,000 advance was obtained fraudulently and sort of was just pushed out the door along with the loan very quickly. I believe the application was in May or June of 2020 for an individual claiming he had a car wash business that just did not exist. There was no business, there were no employees, the entire application was sort of falsified. I will note that you don't see a ton of EIDL prosecutions, in part because the dollar amount is low, which is again another area that the OIG for the SBA noted that because it's only $10,000, if you look at sort of the threshold for federal prosecutions, it's a pretty low number, which is another reason they're concerned about widespread fraud, because of the ability to actually police all of these grants, given sort of the low numbers. But you'll see, I think, it's in this press release, and if you look at other EIDL cases, this defendant was actually in on other charges, pending federal charges when this EIDL fraud was discovered. So I think in the case of EIDL loans, you'll see that in a lot of cases, it sort of gets picked up when there's something else going on, and then the individual defendant has also committed EIDL loan fraud, just because, again, the dollar amount is so low. The other cases are more representative of the types of criminal prosecutions you should expect to see on the PPP side, where the dollar amounts are much higher. So all of these other examples are of prosecutions where the dollar amount was in the millions. One from the Southern District of Texas, where 7 defendants were charged with sort of a ring to submit 80 fraudulent PPP applications. And then when they received the loan proceeds, they actually sort of took it a step further and paid out those proceeds in fake employee checks. So you can see sort of the level of sophistication increasing in terms of how individuals not only, got loans with fraudulent information, but then actually laundered the money once they had it. And then just 2 other PPP examples, one from our district, where the individual actually created fake tax documents to support the application, and then one from the Northern District of Georgia, again, where you had sort of a ring of individuals with someone recruiting other people to put in applications and also kick back any proceeds that they got as a result of the loans. So again, I think you'll see sort of a shift towards these larger, more sophisticated rings on sort of the individual borrower prosecution side. But I think going forward, and I say that this at every presentation, when I first started in the office, I had a Hurricane Katrina fraud case. That was in 2012, and Hurricane Katrina fraud was 7 years old, had happened 7 years before that. And so I think we're going to continue to see these sort of prosecutions in the very long term, and the longer term investigations are going to sort of move away from these, basic quick hits on the fraud for borrowers and looking at these more sophisticated rings, as well as loan forgiveness, as I said, and lenders, looking both at sort of customer diligence, question of whether SARs were filed in certain cases, for example. And then there are also claims of sort of preferential treatment for certain borrowers that have been reported on sort of widely in the press. And I think that that's an area that you might eventually see prosecutions as well. So I do also want to sort of note that there are, there's a question about identity theft for some of these prosecutions. We have seen some examples of that, and I believe the Southern District of Texas case involves some identity theft aspects as well. So basically individuals using sort of taking or stealing people's identities or businesses' identities to file these loans. We're seeing some of that. We're seeing much more of sort of the straw borrower rings. So not that the person's identity has been stolen, but that they've allowed their identity to be used. They're sort of like a very low-level player in the fraud, but they're allowing their identity to be used so that the individuals perpetrating the fraud have additional legitimate social security numbers. For example, in the Southern District of Texas fraud case, a number of the people who got sort of fake employee checks were in fact real people. They just weren't employees, and they'd allowed their names to be used to help perpetrate the fraud. So we're seeing some identity theft, but we're seeing a lot more, like I said, sort of these straw borrowers, people who aren't central to the fraud, but allowing their information to be used to perpetrate frauds.
Thanks for that, Alex. So, we also have the press releases for these actions in your materials, so you can read about them when we send those materials along after the program. So we're going to turn over back to George to discuss the first ever civil action for alleged PPP fraud. We've been talking about it coming for a while, but there it is. And then he'll also discuss some trends.
Before I get to that, I just can't help but agree with Alex that on the criminal front, I do think for the next decade, there will be full employment for prosecutors and defense attorneys on PPP fraud. So if anyone was worried, for the lawyers out there, they'll be okay. In enforcement developments, DOJ Civil Actions, yes, as we in prior webinars forecasted, DOJ would start bringing civil actions for alleged loan fraud, and as you can see on the slide, that happened last month. In connection with prior stimulus plans that followed national emergencies that had happened, DOJ widely used the tools available to it, including civil statutes such as the False Claims Act and FIREA, the Financial Institutions Reform, Recovery, and Enforcement Act, to bring civil fraud charges and extract large fines and penalties. That's begun here already. Those statutes enable DOJ to bring such civil charges based on a wider array of alleged misconduct, and it happens even on what would be perceived to be relatively smaller dollar amounts. The first case that's reported as brought and settled on January 12th was for a company and its CEO. I'll use allegedly, but they resolved it, falsely claiming that the company was not in bankruptcy when it was a debtor in bankruptcy. The company was called, this was in the Eastern District of California, Sacramento. The company was Slide Belts Inc. It was an online retail fashion accessories company. And it also, as I said, was a debtor in bankruptcy. And, as part of the settlement, the CEO and president, as well as the company, ended up paying damages and penalties of $100,000, but they also, after repeated requests by the government to return the $350,000 loan to the lender, 2.5 months after getting it in early July, they repaid the loan. So some notable takeaways. Again, not the overly egregious conduct that we have been accustomed to seeing now on the criminal side, with people using loan proceeds to purchase luxury vehicles or yachts. That wasn't the case here. While DOJ alleged the company falsely claimed it was not in bankruptcy to obtain the loan, and it applied to multiple lenders at the same time, and included that false assertion in some of that. Again, it was a real company. It wasn't fake. It wasn't fake employees. There were no, made up employee counts for payroll information. And it wasn't the case that the funds were found to have been used for improper purposes. So in any event, the second takeaway will be that the government will seek substantial damages and penalties under the FCA and FIREA, even in a case involving a relatively small amount, as I said, $350,000 here. In that case, the government had made demands for and assertions for that, and asserted that both the CEO and the company were liable to the United States for damages and penalties of almost $4.2 million on that $350,000 loan. So, those are powerful tools, especially FCA and FIREA. Next slide.
George, yeah, before we go there, I just wanted to ask our resident bankruptcy expert on the panel whether companies in bankruptcy could get PPP loans. As you noted, this was a case involving a alleged false statement about the company being in bankruptcy. So I thought, Camille, maybe you could just spend a couple minutes talking about that.
Can you hear me? Can you hear me?
Yes.
Okay, good. Great. Thank you. It went out for a second. Now, the question is whether you can be in bankruptcy and be eligible for PPP loans. The short answer is no, you cannot. But for what we're calling, well, the second iteration of the CARES Act, they do include a provision that certain debtors under certain chapters are in fact eligible. And they'd only be eligible though if the SBA issued determination to make that portion of the law effective. Which chapters are we talking about here? Subchapter 5. Subchapter 5 is a subchapter of Chapter 11 bankruptcies. That chapter deals with high net worth individuals and large corporations over a certain amount. Subchapter 5 deals with small business debtors. To qualify for that subchapter, you must have a debt limit of $7.5 million. And then the other two chapters are family farmers and fishermen, Chapter 12, and then individual wage earners, Chapter 13. The last thing I'll mention is that these categories are pretty narrow. Most large corporations are likely to exceed that $7.5 million debt threshold. And so they'll largely be excluded from being able to secure the PPP loans, one too many Ps. The other thing is that the SBA has not yet issued that written determination to make the law effective. So everyone's sitting around waiting to see if they're going to do that. I think one thing that we're waiting for is for President Biden to appoint a new SBA administrator. Once that happens, it's likely that they'll turn to this and make this section of the law effective, but time will tell.
Thanks, Camille. As you can see, nothing is simple or straightforward, really, when we're talking about this, even when we get into matters of bankruptcy. So we'll turn it back to George for discussion on civil action outlook.
Yeah, sure. Thanks, Pat. And just, continuing it as we forecasted and as has happened, civil actions are on the way and up and running, and the False Claims Act, as per this quote, will get a good workout in this area, and will be, I think, used early and often by the civil divisions of U.S. attorneys' offices.
I didn't get that. Could you try again?
Sorry, Siri's interrupting us here. I think you could expect to see DOJ bring more civil charges based on FCA and FIREA. One of the things I would expect would be, a wide array of alleged unlawful activity, including false certifications that economic uncertainty makes a loan necessary to support ongoing operations of an applicant company. The other one would be false statements concerning the ability to secure credit from other sources. And as is the case on the criminal side, loan forgiveness will be a focus in particular now that we know that the SBA will be extensively auditing forgiveness applications. And then finally, I think with the increase in the government's use of FCA and FIREA to bring loan fraud cases, you'll inevitably see an increase in whistleblower reports and activity and actions under those statutes. The key TAM provisions of the the Foreign Corrupt Practices Act, permit suits by private persons, quote, for the person and for the United States government, close quote. So if the government decides to take on the case that the relator, the whistleblower brings, and then the suits will then be investigated by DOJ, the whistleblower can obtain, a nice recovery or reward. Whistleblowers can obtain 15 to 30% of any recovery, whether or not DOJ decides to join in and take over the suit. Under FIREA, whistleblowers can file with the U.S. Attorney General a declaration of a violation giving rise to prospective FIREA claims and obtain a share of any government recovery up to $1.6 million. So it's a nice incentive for whistleblowers to get involved. So, companies out there engaging in fraud, people around you, your vendors, your employees, your former employees, anyone who has knowledge of it could blow the whistle. So I think we'll be seeing more of those. Next slide.
Yeah. Thanks, George. And, you know, look, from a compliance perspective, it just further emphasizes sort of the point that companies should have, rigorous whistleblower policies and, and have, internal ways of conducting internal investigations, especially in the context of whistleblower activity with this type of alleged violation. It's always, better to, treat your whistleblower complaints seriously and run them down internally and see if they have any merit or not, as opposed to not doing that and then having to deal with the government investigation that will be alerting you for the first time because you didn't look into it before. So just more emphasis on whistleblower policies and just, having protocols in place for conducting adequate internal investigations when you get internal allegations of alleged fraud. So if we go to the next one, so here's just sort of another thing to look out for with respect to law enforcement actions and investigations for in the realm of COVID relief loans, PPP, EIDL, and others. So the SEC has been in the mix too. They have their own coronavirus steering committee. They've been active, and among other things, the SEC reportedly has been looking into whether companies who take COVID relief loans are saying the same things on their loan applications as they are on their public disclosures. And I think the SEC's focus is enforcing against companies who may be suffering the negative economic effects of the COVID-19 pandemic, but at the same time portraying an overly rosy picture for the investing public. And back in December, the SEC brought an action against a public company regarding the disclosures it made about the impact of COVID-19 pandemic on its business and operations and financial condition. So they've already brought one action in this realm, and they're reportedly looking into these types of issues. And I think the takeaway here is that for public companies, and again the new PPP 2.0 rule excludes public companies, but whether it's in the past or for other COVID relief loans that the company might qualify for, it's just to make sure that that the public disclosures the companies are making, adequately address the non-public disclosures the companies are making, whether that's in COVID loan relief applications, forgiveness applications for PPP loans, and also internal communications or communications with your vendors. So, if the SEC takes a look into the company's public disclosures and also finds that, if the company has, portrayed a favorable economic look in their public disclosures, but at the same time has been trying to, for example, renegotiate a lease because of the negative impacts of COVID-19, then the SEC could see that as an issue. So just something to keep in mind as to sort of the SEC's angle. And of course, as you see on the bottom slide with the new chairman, Gary Gensler, we expect there to be even more focus on the accuracy of public disclosures. So just wanted to raise that. And now we're turn it over to Pete for some discussion on risk mitigation steps.
Thank you, Pat. And okay, so challenges, risks, and mitigations for borrowers. Could have used a few different titles for this slide to include: how do I stay out of trouble? How do I sleep at night? How do I avoid scrutiny? All the different things that one can do to sleep better at night, etc. Having been fortunate to look at the kind of the white collar crime both through the government, from a government perspective with the FBI, and for the last 9 or 10 years on behalf of clients, providing counsel, providing advice to clients, guidance to clients on how best to proceed with their business operations. You know, I look at it, you know, both ways from both perspectives. You know, one of the compelling themes throughout receiving any loans, whether it's from your bank down the corner, any government subsidies, is, you know, the concern that false statements on a loan application, you know, very generally, Title 18, United States Code, Section 1014, false statements on a loan application. You know, there are different versions of that apply to the different subsidies. But something to be concerned with. My intent is not to put the fear of God in you, but something you certainly should be thinking about these from day one. And that begins with the application process. And when I say day one, there's a continuum of concern and document retention and the like that I'll discuss in the next minute or two. Both Alexandra and George referenced earlier the Hurricane Katrina, Fire Rhea, the SIG TARP from back in 2009 with the economic crisis in 2009. You know, the SIG TARP initial funding, I think, was for 3 years on or about late 2009. You know, here we are in 2021, the SIG TARP is still very much alive and kicking. And there's a very slow cadence, but of prosecutions and the like. But the funding has been allocated. The SIG TARP is still alive. Looking at those requests that were made, you know, well over 10 years ago. Similarly, the concern here is upon application, upon record retention and storage that you should be aware of. Somewhat scary, but there was a method to the madness in terms of introducing new documentation to provide for more streamlined and efficient process. Again, that was somewhat upon further reflection. You know, how can we make this a more efficient and effective process? However, it does lead to a potential slippery slope. I don't need to provide documentation. However, 3, 4, 5 years from now, will I be able to produce that documentation, whether it's a law enforcement agency or some government agency that might be requesting you to produce those records. PPP 2.0 also allowed second drawers or second loans for qualifying businesses with additional restrictions. In the differences between 1 and 2, there are differences with regards to what's permissible and what's not, what can be allowed in terms of the monetary amounts. Nothing to be taken lightly. And I believe Pat mentioned early on, we would certainly advocate doing this with your accountant, with your attorney, and do not take it lightly. A lot of the monies that have been drawn upon in both versions, small businesses, somebody who's very, very successful at their respective businesses, whether it's an auto body shop, whatever it might be, but may not be as adept at maintaining records, filling out what could be somewhat complex calculations and the like. Nothing to be taken lightly. You should be looking at this with a lot of scrutiny on the front end to potentially avoid scrutiny 2, 3, 4, or 5 years or more down the road. One of the things that we certainly advocate is that borrowers must document, segregate, and preserve all records related to applications for funding and forgiveness. Requests for forgiveness of loans less than $150,000 do not require documentation, however, need to be made available if and when audited. When I talk about segregating and preserving all records, I'm also talking about segregating the monies, the monies that have been received pursuant to the loan request. There should be a clear record that they're separate and apart from other revenue streams within or other monies that have been received by the organization. And that will help preserve the record, maintain documentation. So when asked, you received $140,000 for the following purposes, back in 2021 or 2020, you need to demonstrate exactly what they were used for, generally used for short-term or current needs of the business. Can't emphasize enough the requirement to document, segregate, and preserve all records. Ensure appropriate internal controls over borrowed monies to include segregation of duties and use of loan proceeds in accordance with rules. And this is somewhat of a point that I discuss with clients each and every day, is the ability to have adequate controls in place, segregation of duties, how many people have access to bank accounts, to both view and disperse monies and receive monies into bank accounts. Very, very important. Things tend to get pretty hazy with the passage of time. But again, that's something that could very well be looked at a few years after you received your monies. Funds must be accounted for and used for their intended short-term current needs, payroll costs, benefits, and mortgage interest, very, very specifically for those purposes. So when you're filling out an application, when you receive your monies, the proceeds of the loan, these are all the points that you should be thinking about very much from day one. If an audit is initiated, whether it's from a government agency or a law enforcement agency, will I be able to demonstrate that I've taken all these necessary steps? It will make your life much, much easier down the road.
Thanks, Peter. So I think we'll move now to the last slide. I'm going to repeat some of the things you said, and it's funny because we've had this 5 key takeaway slide for a couple of these webinars, and it's always the same takeaways, and it really is the same takeaways as we go forward with the program changes and the rule changes. And there's really basic things that you could keep top of mind that will help you navigate through the borrowing and the forgiveness phases. And the first one is stay informed of the latest developments. The big development here is the Economic Aid Act, and with all the sort of program changes that went along with that. There's, and when the PPP was first established, and after the CARES Act, there was almost daily updates and guidance by the SBA on sort of loan eligibility requirements and use requirements and all that stuff. And that is still happening. So, the SBA will continue to release answers to frequently asked questions on their website. We have the most current iteration of that in the program materials that you'll receive later. They'll loan forgiveness FAQs as well. We included the most current iteration for that in your materials, but those things are constantly changing. So just keep abreast of that. And also the loan applications too. The loan applications have a lot of good information in there, and the forgiveness applications, and those are revised by the SBA as well. So just stay informed of the latest developments, and that'll really serve you well as you navigate these things. And study the rules, like we mentioned throughout the webinar, they can be quite complex, especially when you're getting into the calculations part of it. So, always consider engaging experienced counsel, your accountant, when filling out these loan applications, determining whether you're eligible, how much you could borrow, and ultimately how you're going to get forgiveness. Be careful when you're completing those applications. As Alex mentioned, and as George went through too, these loan applications are heavily scrutinized, audited by the SBA, form the basis of the criminal actions, the false statements in the loan applications that have been out there already. And as we go forward, more attention likely will be spent on the forgiveness applications. So really carefully completing these loan applications and forgiveness applications, being accurate and really paying attention to them, because others will be paying attention to them, is a key takeaway here. And on the fourth and the fifth points over there, established controls over use of loan funds and maintain documentations. Peter went through it. Is the best way to confront an audit, our worst law enforcement investigation, is to be able to show exactly where each dollar received under the program. Maintaining those segregating accounts and keeping good documentation as it happens really will serve the company well in audit, or again, have worse than a government investigation. So that will conclude the substantive part of our webinar. I think there's a couple of questions that are outstanding out there that we could go through quickly. One is the measurement of the gross receipts on a cash or accrual basis for the 25% reduction. So, as we noted before, these rules can be complex, especially when you talk about the calculations and, what costs are eligible, whether it's cash or cash accrual. If you look at, the SBA's website, I think it could be either or. There are also rules concerning covered loan periods and when costs have to be incurred and how they have to be incurred. So, I think it's, the answer to this is to really, look at the materials and, consult with counsel or your accountant to really dig into sort of the question of, cash or accrual and when costs have to be incurred for its account. That's really the takeaway on a lot of this, is that it's not as easy to give answers sort of when you're talking about general notions. It's really a matter of, what your company does and, what the specific rules are for that. And again, they're complex, and, engaging someone, who's knowledgeable about this to really take a look at those questions and then be able to give you the advice that's appropriate for what you're trying to do and for your company. There was also a question about although a borrower may satisfy gross receipts test for a calendar quarter, should a borrower consider not taking a second PPP loan if they had an overall increase gross receipts for 2020 compared to 2019? Again, this is a question of loan eligibility. There are the rules are there as we went through it for the second second draw borrowers, but you also have the issue of whether economic uncertainty, current economic uncertainty requires that or necessitates the funding. So it's an overall mix when you're looking at sort of a business decision as to whether a loan should be taken. And again, it's something that I think you ought to sit down with experienced counsel, accountant, and discuss, again, whether you are eligible under the exacting criteria of the loan programs, and then also whether you will be able to, accurately certify the other things that you have to certify to, such as whether the current, economic situation requires the loan. And then there was one about, has there been anything published on forgiveness qualifications for PPP2? There, in our materials, you'll see that there are revised forgiveness applications that have information in them regarding forgivable costs, and there's other things in our materials. So yes, there has been items published, and we've included materials on that you'll receive after the webinar. Another question, and I'll throw this out to George or Alex, who wants to take it. PPP application contains certification. Current economic uncertainty makes this loan request necessary to support the ongoing operations of the applicant. Say the company submits and gets a PPP loan. How will the SBA look back at this statement if at the time of the application there was a reasonable uncertainty, but in the end the business did fine in terms of revenues? So just throwing that out there. Maybe Alex or George, you want to comment on that one?
Sure. I mean, I think obviously the standard is whether there's economic uncertainty at the time. And I think some of what was discussed by Peter about documentation of that would be very important. So if you can show, for example, at the time there were specific uncertainties, for example, people asking for reduction in budget, or across the industry that you can show that there were certain cutbacks, or you were unable to get loans for a particular period. If you can really show the economic uncertainty at the time, the fact that ultimately it sort of did work out and you didn't sort of suffer from that uncertainty, I think shouldn't change where you were at the time. But it's really important to document that, because obviously if you're sort of from a criminal perspective, when you think about what is reasonable, we often do look at what actually happened. What did you believe was going to happen and what actually happened? And so to sort of avoid any of that hindsight bias, I think, again, speak to a lawyer and your accountant and everything else, but I think the documentation of at the time, what were the uncertainties that you were relying on would wind up being sort of very important to sort of counteract any good luck that you might fall into later, where all those uncertainties didn't come to fruition. But being able to show sort of in sort of hard facts at the time, you had to reduce staff. Like I said, you were unable to use working capital for certain things, unable to get certain loans. If you could document that, I think the fact that ultimately, again, you didn't wind up suffering from those uncertainties or they didn't come to pass, wouldn't change how someone would look at how you behaved at the time.
I agree with Alex on that, and underscoring, as she did, what Peter said about documenting it, memo to the file, because it'll be real hard 5 years or 10 years from now to recall why exactly and what the conditions were when you applied. It could be you were getting a flurry of phone calls or emails from customers, clients, indicating that they weren't going to be in a position to be paying your invoices, that they might be using you as a bank and not paying you, or not being able to pay you because their clients and customers weren't paying them. And that's the kind of thing it's hard to recreate if you didn't document it. And those texts or emails may not be available, when the government comes knocking. So if you would document that in a way that, then, when you end up calling a lawyer and he says, can you recreate the picture? You'd be able to recreate the picture by pulling out your memo to the file.
Yeah, well, good points. So I think then we'll just close with turning it back over. First, thank you all. It's a great panel presentation. Thank you all for spending the time. And just a final takeaway. If you had one takeaway for the audience in closing, what would that be? And Camille, maybe we'll just, start with you for your final thoughts.
Sure. I wholeheartedly agree with everything everyone said, especially about maintaining documentation and staying informed with the latest developments. In the bankruptcy space, the CARES Act had some, changes for people who are landlords of non-residential property and also suppliers of goods. So if you're in one of those categories, definitely talk to a bankruptcy attorney to see if there's anything you should be thinking about in case, a customer ends up filing for bankruptcy. There may be protections that you don't know about. So I'll stop there. I won't bore you with the details of what can happen in a bankruptcy context, but stay informed, talk to the professionals, talk to your attorney, and document.
Thanks, Camille. And Peter, any final thoughts?
As I mentioned a couple of times, the second version here is a streamlined process to make things more efficient and more effective. Most notably, get the money to the people that need those very, very quickly. However, with that, the disclaimer is do not take that lightly. Continue to read through your calculations, read through the application, and maintain documentation for 2, 3, 4, 5 years down the road. Thank you.
Alex, final thoughts for the audience?
Yeah, I think everyone else has sort of made the key points. I do think the staying informed of the latest developments, the SBA updates that website pretty frequently, and they're constantly adding new Q&As. And so I think, just making sure you're sort of on top of what the latest guidance is. I think that goes to, if you're talking about intent and knowledge and understanding of the business at the time that they made certain applications, you should, as part of the documentation, be documenting sort of what the advice from the SBA that you're looking at and sort of what was the status of that advice at the time that you made those decisions.
George, final thoughts?
I agree. I think it's very important, given the fast-paced and changing circumstances of these programs, to get with your consultants, accountants, forensics, law firms, and document. But also use after you document, send a draft of that to your accountant or your lawyer, because their guidance on sort of what should be in there and what shouldn't is going to be helpful as well. And finally, there's a fair amount of a lot of information about these programs out there. There's also some misinformation out there. So I would do what Alex says: go to the source, go to the SBA, go to the source of these programs, and or if you don't have the time to do that, go to your consultants who are doing that and your lawyers.
Very good points. Thank you all again. Also, thank you to the participants, and who knows, maybe we'll see everybody again in a couple months. There's a new legislation that's going to be coming out, and that may also have some updates to the programs that we're talking about today. So thank you all. Enjoy the rest of your day, and thanks for spending your time with us.
Please record the code RISK2 for the post-program evaluation in just a moment. Please make sure to write down this code if you are requesting CLE credit: RISK, the number 2. And finally, to wrap up with CLE, if you're seeking CLE credit, please fill out the post-program survey with your bar number and the 2 CLE codes. You can access this survey a couple ways. Option 1, you can use your phone camera to scan the QR code displayed on the screen right now. Option 2, you can click the survey link in our webinar chat box. Option 3, the survey will show up in your internet browser when we end this Zoom webinar. And option 4 will also include the link in our follow-up communication to you, along with a copy of the slide deck, a recording of the webinar, and the additional resources that Pat and the team mentioned throughout the program. Thank you once again to our panelists, and thank you to our guests for joining BakerHostetler today.
Kristen, before you there was a question about risk 2, whether there's a space between the risk and 2, or it's without a space. Maybe you could put the slide back. There you go. So that's what it is. I think it's with a space.
Yeah. And it, as long as you have the code, you are good to go.
Thank you, Kristen. Thank you very much for facilitating this. And again, thank you all, and enjoy the rest of your day.
Thank you.